Washington State has one of the most heavily regulated tenant screening environments in the entire country. If you're screening tenants in Washington, you need to understand a complex framework of state laws and local ordinances that impose significant restrictions on application fees, criminal history, source of income, and the entire screening process. Getting this wrong can result in substantial penalties. Let's start with application fees, because Washington has strict rules. Under RCW 59.18.257, landlords can charge a screening fee, but the fee cannot exceed the actual cost of obtaining the screening report. The landlord must provide the applicant with a receipt and an itemization of what the fee covers. If the landlord doesn't actually obtain a screening report, for example, if the unit is rented to someone else before the screening is completed, the landlord must refund the fee. Washington also requires landlords to provide applicants with specific screening criteria before collecting the fee. Under the same statute, the landlord must provide a written statement of the screening criteria, including credit requirements, income thresholds, rental history standards, and criminal history criteria, so the applicant knows what standards they'll be evaluated against before paying. This prevents applicants from spending money on a screening when they clearly wouldn't meet the landlord's criteria. If the landlord fails to provide the screening criteria in advance, the fee must be refunded. This upfront disclosure requirement is one of the most tenant-protective screening provisions in the country. It means landlords must have their criteria documented and ready to share before they begin accepting applications. Criminal history screening in Washington is heavily restricted, and the rules have changed significantly in recent years. The state enacted RCW 59.18.580, which places specific limitations on how landlords can use criminal records in screening decisions. Under this law, landlords cannot consider arrest records that did not result in conviction. Landlords cannot consider criminal convictions that have been sealed, expunged, or vacated. Landlords cannot consider juvenile records, and landlords are limited in how far back they can look. They cannot consider convictions that are older than a specified period, with the look-back period depending on the type of offense. For most offenses, landlords cannot consider convictions older than 7 years. Washington also requires landlords to conduct an individualized assessment when considering criminal history. This means you cannot have a blanket policy of rejecting all applicants with criminal records. Instead, you must evaluate each applicant individually, considering factors including the nature and severity of the offense, how much time has passed since the conviction, the applicant's conduct since the conviction, and the relationship between the criminal conduct and the tenancy. You must provide the applicant with an opportunity to present mitigating information before making a final decision. If the landlord denies an applicant based on criminal history, the landlord must provide a written notice explaining the specific conviction that formed the basis for the denial and how the landlord applied the individualized assessment factors. This goes significantly beyond FCRA's standard adverse action requirements. Seattle has enacted even stricter criminal history screening rules under the Fair Chance Housing Ordinance. Seattle landlords cannot inquire about criminal history at all during the initial application process. The landlord must first evaluate the applicant based on all other criteria, income, credit, rental history, and can only conduct a criminal background check after making a conditional approval. If criminal history is then discovered, the landlord must conduct the individualized assessment and give the applicant the opportunity to respond before making a final decision. Seattle's ordinance includes specific penalties for violations, including damages and attorney's fees. Tacoma has also enacted local screening restrictions that add requirements beyond the state law. Landlords operating in Tacoma should review the city's current ordinances for specific provisions. Source of income protection is robust in Washington. Under RCW 59.18.255, landlords cannot discriminate against applicants based on their use of housing choice vouchers, tenant-based rental assistance, or other lawful sources of income. This means you cannot reject an applicant simply because they receive a housing voucher, Social Security, disability payments, veterans benefits, or other government assistance. The income still needs to be sufficient to cover the rent, but the source of that income cannot be the basis for denial. Washington's source of income protection is one of the strongest in the country and is actively enforced. The Washington State Human Rights Commission investigates complaints, and violations can result in damages, injunctive relief, and civil penalties. Landlords who have policies stating they don't accept vouchers or government assistance are in clear violation of state law. For credit reports, Washington follows FCRA requirements for permissible purpose and written consent. The adverse action process follows federal requirements plus the state's additional disclosure obligations. When a landlord denies an application, the landlord must provide the reason for the denial. And if the denial was based on screening report information, the landlord must identify the specific information that led to the decision. This is more detailed than what FCRA alone requires. Washington also has a specific provision regarding the timing of screening. Under RCW 59.18.257, the landlord must complete the screening and notify the applicant of the decision within a reasonable time. The intent is to prevent landlords from holding applications indefinitely while collecting fees. Washington's fair housing protections under the Washington Law Against Discrimination, RCW Chapter 4960, are among the broadest in the country. Protected categories include race, color, religion, national origin, sex, sexual orientation, gender identity, disability, familial status, marital status, veteran or military status, and use of a service or assistive animal. The breadth of Washington's protected categories means that screening criteria must be carefully crafted to avoid even unintentional discrimination. Washington's notice requirements for rent increases, 180 days, the longest in the country, also affect the screening context indirectly. The state's overall tenant protective legal environment means that tenant advocacy is strong, enforcement is active, and non-compliance carries real consequences. From a practical standpoint, Washington's rental market is one of the most dynamic and expensive in the country, concentrated heavily in the Puget Sound region. Seattle has extremely high rents and strong demand driven by technology. Amazon, Microsoft, Google, Meta, and hundreds of other tech companies, healthcare, biotech, and the Port of Seattle. Seattle's Fair Chance Housing Ordinance makes it the most restrictive city in the state for criminal history screening. Landlords in Seattle must treat the city's ordinance as their compliance baseline, not state law. Bellevue, Redmond, Kirkland, and the East Side communities have similarly high rents driven by the tech economy. Microsoft's Redmond campus and the broader East Side tech corridor create enormous rental demand. These communities generally fall under state law rather than Seattle's ordinance, but the screening requirements are still substantial. Tacoma has a growing rental market with its own local ordinances. Spokane, the state's second-largest city, has a more moderate market driven by healthcare, education, and government. Vancouver, across the river from Portland, Oregon, has a strong market influenced by both Washington and Oregon economies. Olympia, the state capital, has a market driven by government employment and Evergreen State College. The military communities around Joint Base Lewis McChord, including Lakewood, Tacoma, and the surrounding area, represent one of the largest military rental markets in the Pacific Northwest. Military tenants' income is documented through leave and earnings statements and BAH rates, and landlords near JBLM should understand military income verification procedures. College towns including Pullman, home to Washington State University, Ellensburg, home to Central Washington University, and Bellingham, home to Western Washington University, have student-influenced markets with seasonal turnover and applicants who may have limited credit and rental history. Screening students requires a consistent approach to evaluating applicants with thin files, such as accepting cosigners or guarantors. One critical best practice for Washington landlords: document your screening criteria in writing before you begin accepting applications, because the law requires you to share those criteria with applicants before collecting a fee. Your criteria should clearly state your credit score threshold, income to rent ratio, rental history requirements, criminal history evaluation process, including the individualized assessment factors, and any other standards you apply. Having this document prepared in advance is not optional in Washington. It's a legal requirement. Another best practice: train everyone who handles applications on Washington's criminal history rules. The individualized assessment requirement means you cannot simply run a background check and issue an automatic denial based on what comes back. Every criminal history result requires thoughtful evaluation, documentation of the assessment factors, and an opportunity for the applicant to respond. Failure to follow this process is a violation, even if the ultimate decision to deny would have been the same. For landlords operating in Seattle specifically, build the two-stage screening process into your workflow. Evaluate all non-criminal criteria first, make a conditional determination, and only then proceed to the criminal background check for conditionally approved applicants. Running the criminal check up front violates Seattle's ordinance even if you don't use the results until later. Washington requires landlords to return the security deposit within 21 days of the tenant vacating. The deposit is limited to 1 month's rent under most circumstances. Given the screening restrictions, thorough but compliant screening is your most important tool for selecting reliable tenants because your financial protections through the deposit are limited. For the complete guide to Washington tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.